everyone, I hope you all are doing well. In this video, I will talk about the essentials and legal rules for a valid contract. In my previous video, I explained the term contract, agreement, and promise. We know that a contract is an agreement enforceable by law. An agreement is enforceable by law if certain conditions are fulfilled. These conditions are also called essentials and legal rules for a valid contract. The conditions of enforceability are given in Section 10 of the Indian Contract Act. The first condition of a valid contract is offer and acceptance. In an agreement, there are at least two parties. An offer is the starting point of an agreement. To create a legal relationship, the offer made by one party must be accepted by the other party. Let me give you an example. Raju offered to sell his motorbike to Ramu for rupees 20,000. Ramu accepted his offer. So this is a valid contract. Now we move on to the second condition. Intention to create legal obligation. The parties in an agreement must have the intention to create legal obligation. Legal obligation means legal duty of the parties. If a party fails to perform his or her legal duty, that is promise, the other party can take legal action. To have a legal relationship, the parties must enter into a commercial or business transaction. Legal obligation is absent in a social or domestic or moral agreement. Let us understand this point with an example. Sita and Geeta are two friends. Sita invited Geeta to dinner and Geeta accepted her invitation. There is a social agreement between these two friends. If Geeta fails to attend the dinner, Sita cannot go to the court to file a case against Geeta because there is no legal obligation in a social agreement. The third essential of a valid contract is lawful consideration. Consideration is one of the most essential elements of a valid contract. Consideration means something in return. The something in return must be lawful. It should not be fraudulent, forbidden by law, immoral, or opposed to public policy. Let us understand this point with an example. Mr. Bob promised to obtain an employment for Mr. John in a government department, and in return, Mr. John promised to pay him rupees 2 lakh. The agreement between Bob and John is not a contract because the consideration is not lawful. Next essential of a valid contract is lawful object. Every agreement has some objects or purposes. The object of an agreement is lawful if it is not forbidden by law, not fraudulent, immoral, or not opposed to public policy. Let us understand this point with an example. Ram, Shyam, and Raju entered into an agreement that they would enter Babu's house to commit theft and divide the stolen things among themselves. This agreement is not valid because the object is unlawful. Now we move on to the fifth essential element of a valid contract, capacity of parties. The parties must be competent to contract. Every person is competent to contract who has attained the age of majority, is of sound mind, and is not disqualified under any law. Let me give you an example. Ramesh was a minor. He borrowed rupees 30,000 from Manish by fraudulently representing himself as a major. This is not a valid contract because an agreement with a minor is not enforceable by law. The sixth essential of a valid contract is free consent. The parties in a contract must agree upon the same thing in the same sense. That is, they must have meeting of minds. And the consent given by them must be free. That is, without any force or threat. Let us understand this point with an example. Geeta had 2 cars, Alto and Centro. She offered to sell Sita her Centro car, but Sita thought that Geeta offered her Alto. So she accepted her offer. In this case, the parties did not agree upon the same thing in the same sense. So there is no contract. Now we move on to the next essential of a valid contract, that is certainty of meaning. The terms of an agreement must be certain. It means the terms of a contract should be clear to the parties. Contracts which are uncertain cannot be enforced in the court of law. Example: Rahul agreed to sell to Sanjay 2 quintals of rice. In this agreement, it is not clear what kind of rice. So this agreement is not valid because it is not certain. Now we move on to the next essential. Performance of an agreement must be possible. The performance of an agreement must be possible in the eyes of law. An agreement to do an impossible act is void, that is, not enforceable in the court of law. Let us try to understand this point with an example. Sita's mother was dead, and Raja promised her that he could talk to her dead mother. And in return, Sita promised him that she would pay him rupees 10,000. This is an impossible act in the eyes of law, so it is not a contract at all. Next essential, legal formalities. An oral contract is a valid contract, but in some cases it must be in writing. Example: Deepika agreed to sell a plot of land to Mahesh for rupees 10 lakhs. This agreement must be in writing, registered and properly stamped. An agreement dealing with immovable properties must be in writing. The next essential element of a valid contract is that an agreement must not be declared to be void. Certain agreements are expressly declared as void by the law. If a party enters into such type of agreement, then it shall not be enforceable by law. Let me explain this point with an example. Pradeep enters into an agreement with Deepa that if she does not marry throughout her life, he will pay her rupees 5 lakhs. This agreement is not valid because an agreement which prevents a person from marrying is void. So we may say that when an agreement satisfies all these conditions, the agreement will become a contract. That's all for today. Thank you very much for watching.